Hello. Good afternoon, good evening, Sat Shri Akal. कैसे हो? Sorry, I cannot speak in Hindi. I forgot. How are you all? I hope you all are doing fine, wonderful, and outstanding. So this said Professor Shubham Joshi, law ka Anna, law ka Bhai, brother of law. Brother of law does not sound that cool. Law ka Anna sounds cool. Law ka Bhai also sounds very cool. So without wasting any time, let us begin with Indian Contract Act. So today we'll be solving around, let us say 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16 questions of Indian Contract Act. We all know that Indian Contract Act is one of the most tedious topics that there is in our curriculum, correct? Whoever has come and whoever is watching the session, please don't forget to like, share, subscribe, and yes, do not forget to mention who you are, because if you're not studying law from me, then what are you doing in life? So let us focus on understanding Indian Contract Act. Let us not waste any time. Let us begin with the practical questions first, and then we'll go to the direct question part later. Okay, we'll start with hello Meraki school. Who is this? Who is this? Hani Singh. Who is this? I think I know you. You are the next influencer of this generation. Yes or no? You're the next upcoming influencer of this next generation. नए generation के उभरते सितारे हो मेरा की school. Correct me if I'm wrong. Okay, chalo. So we'll start with distinguish between quantum merit and anticipatory breach. We're going to start off with difference between quantum merit and anticipatory breach. Now, if you have studied Indian Contract Act, you know quantum merit means as much as is. What is the meaning of? I miss you too, sir. Let's connect over call someday whenever you are free. Okay. Yes. Hi Kamesh. Hi Arunachal Murna. I may be wrong with pronunciation, so please forgive me. I am very sorry if I'm taking wrong names. Okay. Do not take it personally. Okay. Chalo. Let's begin. So all dear students, whoever is watching the session, let's begin. JIGL marathon will be done, my dear. It will be happening soon, but not immediately. We'll do it in the month of November, okay? Or most probably, yeah, we'll be doing it in November, okay? Okay, Selvi. I'll call you Selvi. Okay? Yes. How can so many people are watching and there are no likes? This is not good. This is so toxic of you all, man. I mean, so many students are there and not a single like. Why? Why? Chalo, let's begin. Let's begin. Quantum merit means as much as is. What is the meaning of quantum merit? Quantum merit means as much as is earned. And what is the meaning of anticipatory breach? Breach of contract. You are breaking the contract before the performance of contract. So, first things first. Let us understand breach of contract with one example and then we'll go to the answer. Ready, everyone? Now, imagine that today we make a contract. So today it is the date of contract. Date of contract is 21st August. 21st August. Date of contract is 21st August. The date of performance is date of December 30th. Which means today you and I, we are entering into a contract and I am telling you that you have to sing for my son's birthday party, which will be on 30th of December. So we made a contract today. And when are you going to perform the contract? You are going to perform the contract on 30th of December. Are you all with me till here? Did you all understand this? We made the contract on 21st of August. We made the contract on 21st of August. It will be performed on 30th of December. Did you understand this? Date of contract is 21st August. Date of performance is 30th of December. Now, somewhere here in between, let us say that in the month of October, you tell me that I will not sing. Okay, I will not sing. Now, if you tell me that you are not going to sing, let us say that you have told me on 11th October, you have told this to me on which date? 11th of October, that you will not be going to sing for my son's birthday. Did you break the contract? Yes. Who is the person with whom the wrong thing has happened? I am the person with whom the wrong thing has happened. So I would call myself as an aggrieved party. I would call myself as an aggrieved party. I am the person with whom the wrong thing has happened and I am the aggrieved party. Now, please try to understand on what I am saying. I will not sing is what I told. I will not sing is what I told to you, correct? You told me, correct? Now, I am the aggrieved party. I have two options. You said you will not sing. I am the aggrieved party. I have got the damages. Now I have two options. I will wait till the actual date of performance, or I will sue immediately for breach of contract. Okay, did you all, whoever is watching the session, did you all understand this? We made the contract today that you will be performing for me on 30th of December. Now on 11th October, you tell me that you will not be singing. Once you say that you are not going to sing, I am the aggrieved party. I am the aggrieved party. Aggrieved party means the person with whom the wrong thing has happened. I have two options. Either I will wait till 30th of December, that what if you change your mind, or I will sue you immediately for the breach of contract. Is this clear to everyone? Is this clear to everyone? Yes, is this clear to everyone? Okay. Now, this 11th October that you broke the contract before the performance of contract is called as anticipatory breach. Breaking the contract before the performance is called as anticipatory breach. Now they have asked you that what is the difference between quantum merit and anticipatory breach. Quantum merit means as much as is performed. You pay for what you have performed, not for the entire thing. If you and I book a cab from, let us say, my house till airport and the cost is 500 rupees. You drop me in the middle of the road. Okay, or I get down on the middle of the road. Can I say that I will not pay 500 because you are not dropping me to the airport? I'm not getting down that airport. Yes, I can say that. But can I say that I will not pay the entire money to you? No, I cannot say that. I have to pay for as much as I have received. What was the contract? From my house till airport you are going to drop me, and the total price that I have to pay is 1200 rupees. Sorry, 500 rupees. What is the total price I have to pay? 500 rupees. Now, I see my friend who is driving a car, so I tell you to stop the auto rickshaw in between, and I get down from the auto rickshaw. Now tell me one thing, my dear student, if I get down from the auto rickshaw in middle of the road, can I say that I will not pay anything to you? No, I have to pay as much as I have earned. This question was asked in June 2022 for 3 marks. For how many marks was the question asked? It was asked for 3 marks. Quantum merit means as much as is earned. That is payment in proportion to the work that you have done. If a contract cannot be completed and one party has already performed some work, see, did you perform your part? You took me in auto rickshaw, right? You took me halfway, right? But the contract was not completed. The contract would have been completed if you would have dropped me to the airport, correct? He may get payment proportionate to the work done. You did something, you will get money for the proportion of work that you have done. In case of breach, the aggrieved party can claim quantum merit plus damages. Whenever there is a breach of contract, if you break the contract and I have performed some part, I can claim money from you. Now, what is the meaning of this? As much as is earned means there is a person who wants you to sing at his restaurant. You sang here, you sang here, you sang here. He did not call you over here. Then you went here, you sang over here. Now he's telling you, I will not pay money to you because you did not sing for 1, 2, 3, 4, 5 nights. He's saying that I will not pay you for 5 nights. You'll say, no, you have, the contract is not complete, I know, but you have to pay for what I have performed. You have to pay for what I have performed. Is this clear? Is this clear? Is this clear to everyone? Did everyone understand this? Okay. Now, so in case of breach, whenever the contract is broken, the aggrieved party can claim quantum merit plus damages. It is available only when the original contract has been discharged. It is available only when the original contract has been discharged. Okay. Anticipatory breach will come when a party to a contract declares before the due date that he will not perform the contract. I gave you this example, right? October wala example I gave you, right? Do you remember the October wala example, December? You are telling me in the month of October that you will not be singing for my sons or sisters or daughters' birthday. Correct? Okay. Now, the aggrieved party has two options. Did I not also write the two options? What are the two options that the aggrieved party has? Either he will cancel the contract immediately and claim damage, or he can keep the contract alive and wait till the due date. He can keep the contract alive and wait till the due date. Did we not study the exact thing? Did I not teach you the exact thing, my dear students? Did I not teach you the exact thing? See, wait till the actual date of performance or sue immediately for breach. Same thing has been written over here. If the aggrieved party keeps the contract alive and meanwhile the government imposes a ban, the contract will become void. He cannot claim damages. Thus, quantum merit relates to payment for work already done, and anticipatory breach means refusal to perform the contract before the due date. Now, sir, what is this government wala point? Now, if you are my student, you would remember Satyabatra Ghosh versus Mugnu Ram's case law. You might remember Satyabatra Ghosh versus Mugnu Ram's case law. How many of you remember Satyabatra Ghosh versus Mugnu Ram? I'll give you an example. There was a person. No, this was Boden's case law, not Satyabatra Ghosh versus Mugnu Ram. Sorry, it was Boden's case law. Okay. Now, there is a person who is staying in country 1 and there is another person who is staying in country 2. Okay. The person in country 2 is Mr. Kumar. The person in country 2 is Mr. Kumar. And person in country 1 is, let us say, Mr. Steve. Okay, there are two people. One is Mr. Steve and one is Mr. Kumar. Okay. Now, Mr. Steve has a boat. Mr. Steve has a boat. Kumar needs this boat in the month of December. When does he need this boat? He needs this boat in the month of December. Now, listen carefully. They make a contract today. Okay, they make a contract today. Today is 21st August. What is the date today? The date today is 21st of August, and they make a contract today that Steve will provide boat to Kumar. This is Mr. Steve. He will provide a boat to Mr. Kumar. Okay, and this is Mr. Kumar. This is Mr. Kumar. Correct? They made this contract on August that in December 31st, he will get the boat. Now, listen carefully to what is happening. That government point that is there, that is very important. Okay, listen carefully. Now, somewhere in the month of October, Steve tells you that, sorry, sir, I will not be able to provide the boat to you in the month of December. Now, my dear students, which type of breach is this? Is it anticipatory breach or actual breach? He's telling this to us in which month? He's telling this to us in the month of October that he will not be able to provide the boat to us. Correct? That is what he has said. He will not be able to provide the boat to us. Is that what he said? Correct? Now, please tell me which type of breach is this? This is anticipatory breach. This is anticipatory breach. Okay. Now, if Steve has broken the contract, look at the red circle. If Steve has broken the contract, Mr. Kumar is the aggrieved party and he has two options. What are the two options that he has? He can sue immediately or wait till the actual date of performance. Correct? Now, Mr. Kumar decides to wait till December. Mr. Kumar decides to wait till December. Now, he decides to wait. But what happens is, in the month of November, country 1 and country 2 go at a war. Country 1 and country 2 go at a war. Okay. Nice lawyer. If anyone needs any legal advice, you can have a word with my associate. I mean, I should be calling myself as an associate for Mr. Kulkarni. Okay. Listen carefully. Now, please tell me one thing. Please tell me one thing. If the person who decided to wait till December, the person has decided to wait till December, and in the month of November there is a war between these two countries, the contract will automatically become void, which means that contract, as per the contract, this person will not be able to sue or recover any money, because now there is a war and the entire contract has become illegal. Is this clear? Is this clear to everyone? Is this clear to everyone? Yes. So read the line again. Read the line again with me. Okay. See, if the aggrieved party keeps the contract alive, and meanwhile the government imposes a ban which makes the contract void, the contract has become void. The contract has become void. Correct? You cannot claim damage. You waited. You thought that you are aggrieved party. You are an aggrieved party. You don't have to think. You are an aggrieved party. You decided to wait. But what happened? There was a war. Or government decides to change certain policies which makes your contract void. Now you cannot claim any damage. Now you cannot claim any damage. Is this clear to everyone? Is this clear to everyone? Clear? Okay. Now, next question, June 2022, 3-mark question. Raman borrows 5,000 from Bowman and promises to pay 10,000 if he fails to repay on the stipulated date. Is Bowman entitled to recover 10,000? Okay. Is Bowman entitled to recover 10,000? Okay. Now look at the provision. As per section 74, when a contract specifies an amount payable in case of breach, the aggrieved party is entitled to reasonable compensation, but it cannot exceed the amount specified in the contract. Raman borrows 5,000 from Bowman and promises to pay 10,000 if he fails to repay on the stipulated date. The amount of 10,000 is amount fixed in the contract. However, Bowman cannot automatically recover the full 10,000. The court will decide the reasonable compensation. So Bowman is entitled to reasonable compensation, but in no case can the total compensation exceed rupees 10,000. Is this clear? Is this clear? Is this clear to everyone? Is this clear to everyone? I hope you guys have understood the entire question. Easy. This was a very easy question. Okay. So what does this say? It says that if any amount is specified, then you can recover that amount, but the amount that you are recovering will not exceed the amount that is mentioned in the contract, and court will give you a reasonable fees, reasonable amount. You cannot ask for any arbitrary amount. Now, what is the position? The position of finder of lost good is that of Bailey. Comment asked in June 2014 for 5 marks. Everyone, what is the meaning of finder of lost good is Bailey? What is the meaning of this line? The position of finder of lost good is that of Bailey. What is the meaning of this line? The finder of lost good is like a Bailey. What is the meaning of this line? If you are my student, you have studied with me. Even if you have not studied, you must know the concept of Bailey. Bailment. Yes. 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 I'll explain this point to you with a very easy example. Kindly focus on screen. Okay, kindly focus on screen. See, if I find lost goods anywhere, if I find lost goods anywhere, I have to search for the owner. And if after a reasonable search owner is not found or goods are perishable in nature, then in that case, what will I do? And there is one more point, that the cost of delivering the goods is more than two-thirds the value of goods. So if you have studied these points, you know all of these things, right? You know all of these things, right? Now, if I am a finder of lost goods, I have to search for the real owner. If the real owner is not found after reasonable search, or the cost of giving the goods is two-thirds, the cost of giving the goods is two-thirds of the value of goods, or the goods are in perishable or of perishable nature, then the finder can sell them in market. This is what we have studied. Plus, until he finds the real owner, if he is not selling it, until he finds the real owner, that is in this situation and this situation, he has to keep the goods as a bail. He has to keep the goods as a bailey with him. Now, this is the most important point. If you were my student, you would remember the example that I gave in class, that I find a wallet, I find a wristwatch in a restaurant, and I take that wristwatch and I see any name or any initial. There is no name or initial. So I asked people around. No one says that the watch belongs to them. So what I do is I give this watch to the restaurant's manager and I tell him that please give this watch to the owner of the watch. If anyone comes for the watch, if they are looking for the watch, give it to them. Now, please try to understand the problem over here. I found the watch. This is me who has found the watch. Correct? I found the watch at the restaurant. I gave this watch to the restaurant's manager. And I told him that you keep the watch with yourself. I looked for the person, but no one was there. No one claimed that the watch belongs to them. Now, I gave this watch to the manager of the restaurant. After 10 days, I happened to visit to the same restaurant again. Now, I asked the manager, sir, this is after 10 days, okay? This is after 10 days. I asked the manager, sir, did you find the owner of the watch? He says, no, sir, I have kept the watch here. See, now if I take the watch from him and I keep it to myself, will I be allowed to do this? Or can I ask the restaurant manager to give me the watch? What is your answer and what is your opinion on this? Can I ask him to give that watch to me? Yes. Can I ask him to give that watch to me? Yes. Please tell me. Can I ask him to give that watch to me? Please tell me. Please tell me, can I ask the owner of the restaurant to give that watch to me? I went in the restaurant, I had food, I saw a watch, I found it, I kept it with myself. I asked the people around, no one said that the watch belongs to them. I gave it to the restaurant manager. Then after 1 week, I go to the same restaurant. I asked the manager, did the owner come to collect the watch? He said that there is no person who came to us claiming the watch. Can I take that watch from him? Yes. What is your view on this? Yes, sir, you can ask as you are the founder, and very good. Very good. So, the question itself is trying to tell the same thing to us, my dear students. The question is saying, as per section 71, a person who finds the goods belonging to another and takes them into his custody is subject to same responsibility as that of a bailee. Bailee must take care of the goods of the bailer as if the goods are of bailee himself. Yes or no? He must take care of the goods as a person of ordinary prudence would do. Okay. He is treated as the owner against the whole world except the true owner. This line changes everything. You have the right against the whole world except the true owner. Tell me, did you understand this? I also gave the same example. Na? I went to the restaurant. I found it. I am the finder of lost goods. Even though the restaurant owner or the manager is, the place where I found it belongs to this person. Even though it is your place, I found it, right? So I have the right to keep it to myself. I will have right against the whole world except for the real owner of the watch. Is this clear to you all? So A finds a diamond on B's shop. He hands it to B to keep it until true owner is found. The true owner does not appear even after an advertisement in newspaper. A claims a diamond from B. B refuses to return it. Can B refuse to return it? Can B refuse to return it? Tell me, can B refuse to return it? Tell me, can B refuse to return it? A finds a watch. Sorry, A finds a diamond in B's shop. He gives it to B, tells B that find the real owner. He puts an advertisement in newspaper, no one comes. A comes and tells me that give it to me, I will keep it to myself. Can he do this? Yes. Please give reason for your answer and like for if you have understood the concept. The concepts are easy. Do not forget to like the video. I can see that someone has not liked the video. Not good, not good, not good. Yes, sir, A can ask. Very good. B is bound to return the diamond to A as A is treated as owner against the whole world except the true owner. Is this clear? Is this clear? Very good. Now, let us solve the next question. Asked for 5 marks in December 2018. Till here, are the concepts clear to you all? Next question is, Mohit finds a ring of Shraddha and sells it to third person, Prachi. Who found the ring? M found the ring belonging to S. Sold it to P. M found the ring. The ring belongs to S. Sells it to P, who purchases it for value and in good faith. Can Shraddha recover the ring? Yes. Yes. Give reason for your answer. There is a guy, Mohit. He finds a ring belonging to Shraddha. He sells that ring to Prachi. Prachi did not know that it is a lost and found ring. She buys it in a good faith. Now, can Shraddha recover the ring? Give reason for your answer first. Sorry. Give reason for your answer, dear students. I want reason for your answer. Yes, what would be the reason for your answer? Everyone, as per section 71 of Indian Contract Act, a person who finds the goods belonging to other takes the good into his custody, acts as the bailee of the goods. He has the responsibility as bailee. Okay, he will be treated as owner against the whole world except for the true owner. Now, Mohit found a ring belonging to Shraddha, sold it to Prachi. Prachi got it for good faith. Did Mohit have the title to the ring? No. So everyone, the sale by Mohit to Prachi is not valid because Mohit had no title. Therefore, Shraddha can recover the ring from Prachi and also can recover damages from Mohit for breach of implied condition as to title under Sale of Goods Act. Now, I don't know why in your Indian Contract Act scanner they have asked this question. This is a question of actually Sale of Goods Act, but more or less it is actually of that topic, finder of lost goods. That is the reason why we are seeing this question. I hope you have understood the question. Okay, now let us understand the difference between contract of indemnity and contract of guarantee. Contract of indemnity and contract of guarantee. In contract of indemnity, the person promises to save another person from loss. If you look at the contract of indemnity, what is the definition? One party is promising to save the other party from loss caused by his conduct of the promiser or any other person. Okay, so if because of me myself, if I am damaging the goods, you will pay for it, or if some other person damages them, you will pay for it. Okay, there are two parties that are involved, indemnifier and indemnity holder. Do you know what is the meaning of indemnifier? Fire is the person who saves. Fire is the person who saves. Fire is the person who saves. Indemnifier. What is the meaning of indemnifier? Indemnifier is the person who saves you from loss. Indemnifier is the person who saves you from loss. Indemnified is the person to whom we are protecting. Indemnified is the person to whom we are protecting. Also, that other person to whom we are protecting can be called as indemnity holder. Okay. How many contracts are there? There is only one contract. Okay. Now, tell me one thing. Very logical and very sensible. Everyone, you promise me to save me from loss. This is a promise that you have made. This is a promise that you have made to me, that you will save me from loss. You made a promise to me that you will save me from loss. Now listen carefully to what I say. The person who saves you is called as indemnity. What is wrong, baby? Wait. Indemnifier. The one who saves you is called as indemnifier. Is this clear? The one who saves is called as indemnifier. And the one who is protected is called as indemnified. Okay. The one who is protected is called as indemnified or indemnity holder. Now, listen carefully to what I am saying. Please listen carefully to what I am saying. Who has, I will write a question for you all. You all tell me. Okay, I'll write a question for you all. Question. Arey, what is wrong? Person who has the primary liability. Who has the primary liability? Is it indemnifier or indemnified? Once the goods are damaged, whose liability is first? See, they have written over here. Yes, whose liability is primary? Because he has promised to pay, na? The liability of indemnifier is the primary liability. Okay. And once he has made a promise, the goods are damaged, the indemnifier is going to remain liable. This liability will be primary. Okay. He is promising to save the person from who is indemnified from a contingent risk. Is this clear? Is this clear to everyone? Now, contract of guarantee. In contract of guarantee, there are three parties and there will be three contracts. Principal debtor, surety, creditor. So in contract of guarantee, how many parties are there? Three parties are there. A, B, C. Look at the line, everyone. Black color ka line. A gives loan to B. A has given loan to B. C says that if B does not pay, I will pay. Okay. So can I call this as second contract? Okay. This is your first contract where A is giving loan to B. This is your second contract where B is saying that I will pay if he does not pay. Now the third contract is here between B and C. What is this third contract? And also in law, they say that this contract can be treated as an implied contract. Implied contract. In law, it is treated as an implied contract. Why? Why? What is the purpose of the third contract? First is I can understand I am giving loan, so there will be a loan agreement. Second is giving guarantee that if it does not pay, I will pay the money to you, give the loan to him. But what the hell is this third contract that you are seeing on the screen? You can be wrong, absolutely wrong. You can be 1000% wrong. I don't mind if you are being wrong. Yes. Please tell me. Yes, please tell me. Okay. I'll give you a logical answer for this. Okay. See. C. Once he pays A is out of the picture. Once C pays A, is out of the picture. Now, can C recover the loan from B? That I paid on your behalf, so you paid to me. This is called as right of subrogation. This is called as right of subrogation. I paid your loan amount. I paid for your liability. Now I have the right to recover it from you. I have the right to recover it from you. Is this clear? So there are three contracts. Now, see, A is the one who gave loan. A is the one who gave loan. A will be called as principal debtor. Sorry, A will be called as creditor. The one who took the loan will be called as principal debtor. And the third person, the one who gave guarantee, will be called as surety. So there will be three parties. So in contract of guarantee, there is a contract to perform promise. He does not perform, I will perform. Or he does not pay, I will pay. Did you understand? A contract to perform promise or discharge liability by a third person in case of his default. So technically speaking, we are saying that contract of guarantee is between them. Contract of guarantee is between them, where this person is saying to him that if a third party does not discharge his liability or the third party does not pay the money, I will pay. I will pay. C has said this to A. This is contract of guarantee for you. Okay. How many contracts are there? There will be three contracts. Now, please help me with understanding whose liability would be primary, whose liability would be secondary. Look at the diagram again. A gives a loan to B. C gives guarantee to A that if B does not repay the loan, I will pay the money. So can we call C as surety? Can we call B as principal debtor, and last but not the least, can we call A as our creditor? Yes. So question is, who has primary liability? Whose liability is primary? Who has primary liability? There will also be a contract between them. I forgot to draw the third line. Very good. Principal's debtor liability is primary. Principal debtor's liability is primary. Surety's liability is secondary. Why surety's liability secondary? Why surety's liability secondary? Because if he fails, then I will pay. Liability of surety is collateral or secondary. Primary liability will always be of principal debtor. Surety can undertake to discharge a liability of principal debtor which is subsisting. A says to shopkeeper, let B have the goods, and if he does not pay, I will pay. This is an example of contract of guarantee. Doubts? Doubts? No doubt? Now, next question asked for 5 marks in December 2017. Okay. Mr. X promises Mr. Y to be responsible for 10,000 due collection and payment by Mr. Z. Decide whether it is a contract of guarantee. Which type of guarantee is it? When may such guarantee be revoked? If you have not understood the question, let me know. I will first hide the answer so that there is no cheating by anyone. Okay, I'll hide the entire answer. I'll hide the entire answer over here. Okay. I am giving you all 2 minutes to read the question and tell me what do you understand in the question. What the hell are they trying to ask you all in this question? Mr. X promises Mr. Y to be responsible for collection and payment by Mr. Z. Decide, is it a contract of guarantee? What type of guarantee is it? Decide, is it a contract of guarantee? Second, what type of a guarantee is it? When may such guarantee be revoked? Yes. Tell me, who is Mr. X? Is Mr. X principal debtor, surety, creditor? Who is Y and who is Z? Yes, establish the relationship of parties for me. I'll establish it for you all. Focus on screen. Okay. Mr. X promises Mr. Y to be responsible for 10,000 from Mr. Z. Mr. X over here is your surety. He's telling Mr. Y that I will be responsible for collection and payment by Mr. Z. So, can I say that Y has hired Z to collect money? Y has hired Z to collect money. Mr. X is the surety. Mr. Y is the creditor and Mr. Z is the principal debtor. I'll draw it here. Mr. X, Mr. Y, Mr. Z. X is surety, Y is creditor, and Z is principal debtor. So X is telling Y that if Z does not collect money of rupees 10,000 properly, I will pay the 10,000 rupees to you. Did you understand this question? Did you understand this question? X is telling Y, allow Z to collect the money of rupees 10,000. If he fails, I will bear the loss. First tell me, did you understand the question, and like the video if you have come here. Like the video. Yes. Very good, Selvi. Now if you have understood this, the concept is very simple. There are two types of guarantees that are there. How many types of guarantees are there? Two types of guarantees are there. One is continuing guarantee, correct? One is continuing guarantee. Another one is, yes, specific guarantee. Now, as per section 129 of Indian Contract Act, when guarantee extends to a series of transactions, it is called continuing guarantee. The liability of surety in continuing guarantee extends to all transactions until the guarantee is revoked. As per section 130, surety can revoke guarantee, continuing guarantee at any time for future transaction by giving notice to creditor. Continuing guarantee cannot be revoked for transaction which has already taken place. So, continuing guarantee means what? You supply tea every month to my brother. I will be liable if he does not pay the money. You have supplied the tea to my brother for 3 months. From 4th month onwards, I am saying don't supply tea. This is continuing guarantee. I am liable to pay for the 3 months for which my brother has not paid, but for future transaction, I will not be liable. X promises Y to be responsible for 10,000 for due collection and payment by Mr. Z. This guarantee extends to a series of transactions. Therefore, this is a continuing guarantee, and Mr. X will be liable to Mr. Y if Z makes any default up to 10,000. Mr. Y may revoke the continuing guarantee for future transaction by giving notice to Mr. Y. Is this clear? Is this clear? Easy? Easy? Doubts, my dear students? Doubts, my dear students? No doubts? Let us see the next question. Question number 41. There is some misprinting in this. So I'll cancel this question. Okay. Look at this question. June 2021, 3 marks. Asked in June 2021 for 3 marks. A puts M as apprentice to B and gives guarantee to B for his fidelity. B promises that he will at least once a month see M and make up the cash. B omits to see this Done as promised, and M embezzles the cash. State whether A is liable or not. 3-mark question, simple. Now over here they have given continuing guarantee. I also thought the same thing, that I thought it is a specific guarantee. Specific guarantee cannot be revoked once the work has started. Specific guarantee cannot be revoked once the work has started. There is some misprint in the question. I'll check that again. This is a suggested answer given. Even I did not understand. I was also of the same thought that it would be a specific guarantee. It should be a specific guarantee. There is some misprint over here. Okay, there is some error over here, but I will check this answer once. Okay, I'll check this answer once. Okay, so Selvi, your doubt is absolutely correct. Okay, now A puts M as apprentice to B and gives a guarantee to B for his fidelity. B promises that he will make at least once a month to see that M is up to the cash. B omits to see this. How many of you have understood the question? See, I'll draw a diagram for this question. Okay. Okay. A is telling M, I give guarantee. A is telling him, I give guarantee. A is telling him, I give guarantee. No, sorry, he's telling B. My bad. A gives guarantee to B. Okay, of M's work. So A is telling B that you hire Mr. M for you. A puts M as an apprentice to B. A puts M as an apprentice to B and gives guarantee to B for his fidelity. Fidelity means what? He will work honestly. He will be working honestly. He will not break your trust. He will not break your trust. So A is giving guarantee. So we will call A as surety. We'll call A as surety. The person to whom guarantee is given is called creditor. And M on whose favor guarantee is given is called as principal debtor. Now in this contract, there is one more line that you need to understand. B made a promise that he will at least once a month check whether M is working properly or not, if he is keeping proper transactions or not. B omits to see this. Now, when they make a contract, B tells A, I will check his work. Okay, but he does not check the work. And M misuses the cash. Did you understand this till here? Did you understand this till here? Okay. Now you have to answer, can A be liable to B under Indian Contract Act? Now, a surety is discharged when the creditor does any act which is inconsistent with the rights of surety. You were supposed to keep an eye on him, right? You did not do it. I am discharged. If he does any act which is inconsistent with the right of surety or omits to do any act which is his duty towards the surety, which requires him to do so. And that was the remedy of surety against the principal debtor, and it is gone. It is gone. It is gone. Is this clear? Now, A gives guarantee, but B was supposed to see whether he is performing correctly or not. B's failure to perform his duty amounts to an omission towards A, the surety. Therefore, he is discharged and is not liable to B. Is this clear, everyone? Is this clear, everyone? Is this clear? Easy? Now, look at the question. Arun. Actually, I did not write the question over here because there was no space. So we'll read it from the facts. Facts and question are the same. A husband enters into a registered agreement with his wife Radha to pay his earnings to her. Husband enters into an agreement with his wife that he will pay earning to her. The agreement is in writing, registered between husband and wife who are in near relation based on natural love and affection. Okay, based on natural love and affection. Now tell me one thing. Is he allowed to pay the money to his wife if there is no consideration? The rule is no consideration, no contract. What is the rule? No consideration, no contract. The rule is no consideration, no contract. But there are exceptional cases that if an agreement is in writing plus out of natural love and affection plus registered plus parties are in near relation to one another. Okay, are in near relation to one another. Then even if there is no consideration coming from wife, the contract is valid. Even if the consideration is not coming from wife, the contract is valid. But there is one more question. In second situation, the husband refers to quarrels and disagreements with his wife and promises to pay her money for maintenance and separate residence. In second case, what is happening? The husband and wife, they are fighting. The husband says that you go and stay separately. I will pay your cost for staying alone. Okay. We cannot stay together. You are fighting with me all the time. I cannot stay with you. Okay. I will give it to you in writing. I am your husband, you are my wife. We have a relation with respect to one another. Now tell me, in the second situation, can the wife claim the money from husband? Whoever is my student has studied this question in class. Look at the question. It was asked in December 2023 for 5 marks. Yes. What will be the answer over here? The answer is very simple, everyone. In the second situation, it is in writing. Okay. It is a registered agreement. It is in writing between husband and wife. They have a relationship with one another. But in the second case, it is not natural love and affection because they are fighting and there is disagreement. There is no natural love and affection because they are fighting and there is disagreement. So, in the second case, it is not out of natural love and affection and the wife cannot sue, but in the first case, the wife can sue. So, as a general rule, agreement without consideration is void. But as per section 25, there are exceptional cases. A promise made without consideration will be valid if it is in writing, that's registered. We made it because we have natural love and affection and parties are in near relationship to one another. And situation 1, all the points are being matched. It is matching. So situation 1 is absolutely right. But in situation number 2, there are fights and quarrels between husband and wife. There are disagreements between husband and wife. And that is the reason why. That is the reason why the husband has said that you go and stay separately. I'll pay for it. Here, it is in writing. It is registered. The parties are in near relation to one another. But is there love and affection? No, the contract is not valid. Is this crystal clear to everyone? So how many questions did we solve today? On Monday. Now the next session will be on Monday. 1, 2, okay, 3, 4, 5, 6, 7, 8. We have solved 8 questions today. We'll solve remaining 8 to 9 questions on Monday. Till then, if you have not completed the previous sessions, do complete watching the previous sessions so that you know the types of answer that you're supposed to write. And if you need any help, comment in the comment section so that I know how I will be able to help you with anything and everything that you need. So that's it for today. See you all tomorrow. Till then, Mamma Mia Lasagna, do whatever you want to do, man. Don't trouble Mata Pita and Bharat Mata. And also enjoy your weekend. Study well, study properly. We will crack December 2026, and we will also crack, if you're planning to give in June 2027, we will crack June 2027. We are with you. You just have to watch, study, repeat. All the very best. Enjoy weekend.